we ready? Start. I am in receipt of your representation dated 12/7/2006 regarding land acquisition and related issues. The issues raised mostly pertain to changes in the existing law for which decisions are to be taken at different levels. The administration has to perform its duty within the existing laws, and therefore there are a number of factors which have to be taken into account. The administration has been acquiring the land for various development projects being implemented for the public good. You will agree that the future of UT Chandigarh does not lie in agriculture. Rather, we have to concentrate and invest in those sectors where the factor productivity is relatively higher and which offer our youth opportunities for advancement. Land is the primary and essential requirement for any project, and therefore the administration has to go for its acquisition. The rate of compensation is determined as per the existing provisions of law and keeping in view the judgments of Honorable Supreme Court and High Courts. The collector rates in Chandigarh have been revised twice during the last year, and the compensation has recently been paid to the tune of rupees 40 to rupees 45 lakhs per acre. The award is further subject to legal scrutiny by courts as the landowner has the liberty to approach them. You would appreciate that the government is not a profit making organization and no surpluses are being generated from the acquisition of land. In fact, the so-called surplus is the value addition due to the change of land use which is invested for the development of the UT. It would also be worthwhile to remind you that the administration has to incur huge expenditure for the creation of public utility services, and a large portion of the acquired land has to be kept vacant to maintain the character of the city. The petitioner does not know as to how much area is needed for either of these purposes, what is the meaning of city level infrastructure, or what is the difference between regulated urban development and planned development. In fact, 100 acres of land is not big enough an area for either of the purposes in itself. Therefore, to enable the right holders to raise objections effectively, they must know as to how much area is required for each purpose, and the purposes mentioned are different from each other. The acquisition of the land in dispute would involve chopping down of fruit bearing trees and non fruit bearing trees. Under the provisions of the Forest Act, no tree in Chandigarh can be cut without permission of the central government. In case the central government decides not to grant the permission to the Chandigarh administration to chop down trees standing on the land in dispute, the entire acquisition proceedings would end up in a nullity with wastage of huge sums of money and man hours. That in any case no resolution for change has been passed for conversion of the proposed land from the zoning area, which is forest land area stroke green belt, prior to the date of the publication of the notice. Thus the notification is vitiated on this ground alone. The proposed acquisition will also disturb the ecological plants and flora and fauna of the area, because the proposed acquisition will also disturb the dense forest area having more than 50,000 grown trees which are more than 30 years old. Forests and orchards are the lungs of a city and have a very important environmental function to perform. Such lands cannot be acquired under the provisions of Land Acquisition Act 1894. The Chandigarh administration has not carried out an environmental impact assessment study, which is extremely necessary before an exercise of this magnitude is carried out. Furthermore, it needs to be pointed out that if the recent happenings in the country are any indication, it is essential to carry out a geological study of the area and conduct surveys before deciding to demolish the green belt around Chandigarh, which the Chandigarh administration has not done. The impugned notification is illegal and void in as much as no plans are available in the office of the land acquisition collector with respect to the alleged city level infrastructure to be set up. There is no plan available for the protection of the ecology and environment and for setting up stroke expansion of the Chandigarh Technology Park. A representative of the petitioner was informed by the office of the chief architect that none of the above particulars stroke scheme stroke site plans were available with them, as none have been framed stroke drawn up by the Chandigarh administration, nor is relevant urban planning data available. It is thus apparent that in the absence of any detailed plans and data with respect to the avowed public purpose, the alleged public purpose is a mere sham and therefore violates the right of the petitioners to effectively object to the proposed acquisition in terms of Section 5A of the Land Acquisition Act 1894. Thank you.